I am assistant professor at Nova School of Law in Lisbon, where I am also the founding director of the recently created Nova platform for European administrative and regulatory law, that is Nova Paro. I would start today by thanking Diritti Comparati for their kind invitation to talk to you a bit about my recently published book, Judging Composite Decision Making, the Transformation of European Administrative Law, which came out with Heart in late 2024. I would begin the very brief explanation of my book by asking a rather strange question. What do genetically modified organisms, major banks, pesticides, and Parmigiano have in common? You would think not a lot. And substantively speaking, that certainly is true. All of these completely different realities are subject to completely different regulatory requirements under European Union law in very different policy areas, from the protection of from the registration of protected designations of origin like Parmigiano, or the single supervisory mechanism in the case of banks. Now, what all of these very different areas, very different issues have in common is that they are governed on the administrative level by uh, by administrative procedures of a very similar structure, that is, composite administrative procedures, which in my book I define as administrative procedures that are based on decisional interdependence, that is, on a requirement that the final decision cannot be adopted without the cumulative exercise of decision-making powers by national and union authorities, um, or by union and national authorities, depending on where the procedure begins and ends. Now, what makes composite decision making so interesting? Well, the book basically contains three parts. In the first part, I demonstrate that that composite administrative decision making simply doesn't fit with the doctrinal status quo of European administrative law. The status quo being since the early 1960s, under the European Court of Justice's case law, the doctrine of European executive federalism, that is, the doctrine according to which national authorities enforce what the union legislature establishes, but also that the national and union level are strictly separate and must be kept separate in the exercise of their own powers. In the case law of the court, one finds the notion of the principle of a strict separation between the powers of the national and the union authorities. And one also sees a notion of a strict separation between the competences of national and EU courts. The latter principle being referred to in EU administrative law literature in recent years as the principle of double exclusivity. So, in the first part of my book, I talk about the mismatch between composite administrative procedures and the doctrinal status quo that I just described of European administrative law, the doctrine of European executive federalism. In parts 2 and 3 of the book, I tried to explain how the European Court of Justice dealt with this mismatch. And how did it do so? Well, gradually it developed, or so I argue, a new doctrinal alternative that departs from the foundations of European executive federalism. No longer is the relation between national and union authorities treated in a separate manner. Indeed, under the new implicit principles that the Court of Justice has gradually developed for the past roughly 35 to 40 years, national and union administration must be treated as a continuum, both in terms of the protection of administrative procedural rights, such as the right to be heard or the right to a reasoned decision, and in terms of judicial protection, say determining which level of courts is competent to review a composite administrative procedure when the final decision results from the exercise of national and union power cumulatively, and there is still a separation between the jurisdictions of national and union courts. So in the book, in parts 2 and 3, I argue that the court has developed implicit principles which I group together in a doctrinal framework that I suggest be called the unitary protection doctrine. And this includes unitary procedural protection, that is the observance of administrative procedural rights in a unitary cooperative fashion, and a unitary judicial protection, that is the the notion that judicial review must be aimed at one of the two levels of administration, which often answers judicially for the actions of both. So, unitary protection doctrine. I also argue that in the court's case law, one finds a simple test to determine which of the two levels within this administrative network that must be treated as basically a unit, the level that is ultimately responsible for the observance of administrative procedural rights, or ultimately responsible to be judicially reviewed if the decision-making process is illegal. The level that is responsible for either is the level that exercises what I term decisional dominance. That is the level that holds the decision-making powers in the composite administrative procedure that will determine the final outcome, be it at the end of the administrative procedure, be it in its preparatory stages with the adoption of binding preparatory acts, both national and European, depending on the administrative procedure that we're talking about. Lastly, I argue that these principles, that the doctrine of unitary protection actually means that the Court of Justice has abandoned, at least in part, European executive federalism. Indeed, if national and union administration are treated as a continuum, as a composite unit, then one can no longer really speak of the very, very basics of federalism, which is that there is such a thing as a division in the power of the national union level, or accurately, in countries like the United States or Germany, a division between the federal and state level, which is the reason why I argue towards the end of the book that in developing this two-track system of administrative law with European executive federalism on the one hand, and for the specific scenario of composite decision making, the unitary protection doctrine, when developing this two-track system, when creating the latter unitary protection doctrine, the Court of Justice developed a form of post-federal administrative law that may well serve as the basis for future developments in the European Union that will frame perhaps a system of administration that is even more integrated than it is today. So that is my book. I hope you will have the chance to read it, maybe find it interesting, and maybe, I would hope, send me your feedback. Thank you for this opportunity to talk to you a bit about my book. See you soon.